Hello. I know it seems like I've disappeared from the planet. I haven't released a video in quite a while. I saw this video today and I wanted to do a commentary on it because I see a lot of good things. First off, this video is on the channel Andre Investigations, who I think does a great job of illustrating what the way that cops are criminal, the way that these entities or these government employees are acting as criminals. And I like his style. So I watched this video today, and I feel like people are starting to kind of get it, but I really wanted to show, like, why Chille DeCastro went to jail. He's Delete Laws is his YouTube channel, so Don Andre's video kind of comes from Delete Laws channel, so I'm just giving credit where credit is due. But I want to comment on this court hearing because I think this exhibits the scam really well, and it exhibits how important it is to understand the court process and what is actually going on in court, because I can see that the defense attorney here screwed up so bad, and I would like to point out some things that may help people down the line in understanding whether or not they have a good attorney, if there is one, or if they have someone who is completely inept and is going to cost them. I believe that Chille went to jail on this because he didn't address the actual issues of the situation and didn't really understand how things were being framed in the courtroom. So I'm hoping I can offer some of my insights based on what I've learned and what we can see in this video. So here we go.
In the dungeon for 6 months.
All right, this is the time set for the trial of State of Nevada versus Jose DeCastro, 23 CR 013015. Is the state ready to proceed?
Yes, we are, Your Honor.
How many witnesses do you have?
We anticipate one.
All right, is the defense ready to proceed?
Yes, Your Honor.
All right. I have your request to convert counsel to standby counsel. I'm going to deny that request. Either you represent him or he should have previously requested a Beretta canvas to represent himself. But I just consider that a delay tactic.
So here's an interesting situation where maybe if I were in Chille's position, what just happened is he requested that, basically Chille is requesting that he can represent himself, but have this attorney, I think his name is Mr. Me, he can have him as a standby counsel, so he can basically ask him for assistance, but he is acting as his own attorney, and she denied it. And one thing that he could have done here is, at this point, fire his attorney, because now it puts everything in a situation where, well, you can't make him represent me against my will, so I'm firing him, and then more things could have happened at that point.
Request is denied. Are you ready to proceed? Otherwise, I'm assuming you are.
Yes, Your Honor.
All right, will the state please call the first witness?
Yes, Your Honor. The state calls Brandon Bork, and he's in the ante room.
Morning.
You're going to remain standing. Raise your right hand to be sworn back. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. State your name for the record and spell it first and last name, please.
It's Brandon Bork.
Sir, good morning.
Good morning.
Sir, how are you employed?
I'm a police officer with the Las Vegas Metropolitan Police Department.
How long have you been employed with Metro?
Just over 8 years.
What is your, what's your occupation there? Like, where are you assigned?
I currently am a field training officer at Summerlin Area Command.
So what's happening right now is the state called this witness. Okay, the plaintiff called this witness, and the plaintiff is doing cross-examination, and she's asked 3 questions so far, and each of them have been direct questions. It falls under direct examination. But what you're going to see is the nature of her questions changes. And just pay attention, you'll notice.
Okay. And so are you a patrol officer
Yes, ma'am.
that also trains newer officers?
Yes.
Okay. And so you were employed as a patrol officer back on March 15th of 2000.
Okay, so now what she's started to do is ask leading questions, which on direct examination she's not supposed to do. So the defense attorney at this point should be objection leading the witness. Once she starts like testifying for him and saying, is this the way it is? Those are leading questions, and that should never happen in direct examination. And a good defense attorney would object to every one of those and say, leading the witness, objection, leading. And the judge should sustain those objections at that point.
2023.
Yes.
At some point in time, did you conduct a traffic stop while you were working in that capacity
Yes, I did.
on that date?
Yes.
Okay. And why did you stop that vehicle?
I had conducted a DMV records check on that license plate, and it came back expired and suspended.
And where is it that you stopped that vehicle?
It was 4155 South Grand Canyon, which was near Target.
Okay.
Now pay attention to the fact that the person that he stopped, their license plate had come back unregistered. So pay attention, keep that fact in mind, because that fact should have been very important in this case. But you'll notice it was ignored by the defense, and the fact that he stopped this person for what he did and then let her go, let her drive away, could have been used in this case, but it never was.
Is that over on Flamingo and Grand Canyon?
Yes.
Okay, and that's here in Las Vegas, Clark County, Nevada, sir?
Yes.
And you indicated it was for a license plate that was expired and suspended?
Yes.
At some point, while you were still in your vehicle, in your patrol vehicle, did something occur that's causing you to have to testify before Judge Zimmerman today?
Yes, I had an unrelated person come over to start recording the traffic stop.
Okay. Can you describe this individual?
He was a white male adult. He was wearing bright colored hoodie and blue jeans.
Okay. That individual, do you see him here in court today?
Yes, I do.
Can you please point to him and describe something he's wearing?
He's wearing a suit and a blue tie.
Your Honor, please let the record reflect identification of the defendant.
So ordered.
And so, what do you do upon seeing this individual approach the driver of the vehicle you had stopped?
Initially, when I saw him, he was just recording. I ignored him, continued my records check. Then when he came over to the driver and started speaking to them, I got out of the car, approached the driver, and told DeCastro to back up.
Okay. And so when you first laid eyes on the defendant, approximately how far away was he from the driver of the vehicle in the Hyundai?
Approximately somewhere within 5 to 10 feet.
Okay. And you indicated that he was recording?
Yes.
Okay. What did you see that led you to believe he was recording?
He had his cell phone camera pointed directly at me.
Okay. And so is that when, upon seeing him being that close to the driver, is that when you told him, you walked up to the driver of the stopped vehicle and asked Mr. DeCastro to back up?
Objection, leading the witness.
Yes, once he started talking with the driver.
Okay. And why is it that you did that, officer?
Well, I can't have unrelated people next to my traffic stops. I don't know if he's a dangerous person, armed. He could be a boyfriend of the stopped person. It's for my safety and the safety of the person I've stopped.
Okay. Because you're also in charge of the safety of the individual that this unrelated individual is making contact with. Is that fair to say?
Yes.
Objection, leading the witness.
Okay. And so you saw it as an officer safety issue as well as a safety issue for the driver?
Yes.
Okay.
Objection, leading the witness.
And so when you approached, well, you said he was recording, the defendant was recording. At any time, did you tell him to stop recording?
No, in fact, I told him he can continue recording.
Okay. He can continue to record given what?
As long as he backed up and gave him an appropriate distance to work.
Okay. And so when you asked the defendant to back up, did he follow your order?
No, he did not.
Okay. And so what did you do next?
I gave him 3 additional warnings to back up.
Okay. And did he obey those orders?
No, he did not.
And what, if anything, did you do with the driver of the stopped vehicle, the Hyundai?
At that point, I chose to release the driver of the Hyundai and then focus my attention on Jose DeCastro.
Okay.
Okay, so what you'll notice so far is that Agnes Botello, the plaintiff, a lawyer, the plaintiff attorney, has been mostly asking direct questions, but she's asked a few leading questions as well. And I'm sure that she has noticed that the defense is not saying objection, leading the witness. So she's going to become more confident in her, in leading the witness, because she knows that the defense isn't going to object to it, right? That's why you have to, even if it seems like a small point, if you notice that the attorney is leading the witness, basically saying, so then this happened, right? Yup. Okay, and then after that happened, didn't this happen? Yes. So that's leading the witness, because direct examination, you're supposed to draw out the witness testimony that you intend to use. And you're supposed to draw it out by asking more open-ended questions, by asking questions that let the witness tell the story. But when you start telling the story as the attorney, you're leading the witness. And when you start telling the story and just asking for yes and no, then you're leading the witness. And that's what's supposed to happen on cross-examination, never direct examination.
The cop on the stand lies and says he didn't step back, but you can see on video that I did step back.
And can you tell Judge Zimmerman the nature of your interaction with the defendant after that?
I ordered DeCastro to the front of my patrol vehicle while pointing at it and told him that he was detained.
Okay. And what was the purpose of detaining him?
For obstructing my initial traffic stop at the Hyundai.
Okay. And did he obey your lawful order?
No, he did not.
And what happened next?
He continued filming me. I continued pointing toward my patrol vehicle, continued telling him he was detained. All the while, he just continued shifting his body around, recording me on the phone, and refusing to go to the car.
Okay. So what did you do in response?
I used my hand to escort him to the patrol vehicle, so I placed my hand on his shoulder, and at that point, he swatted my hand away.
And what happened next?
That's when I grabbed him by the shirt, and I spun him around, and then we ended up at the front of my patrol vehicle. We were both still standing.
At some point, did you request additional units to respond to the scene?
I did. That was before I grabbed him,
Okay.
when I initially detained him.
Okay. And, I'm sorry, once you had him at your patrol vehicle, or the front, the hood of your patrol vehicle, what happened next?
Officer Dingley, another officer in the area, had arrived, and he came over to help me handcuff.
Okay. And were you successful, or did the defendant cooperate in being handcuffed?
He did not cooperate. I told him 7 times to face my patrol vehicle. He did not listen. I told him 6 times to turn around. He did not listen. It wasn't until I told him that he was going to go to jail, that was the consequence of not listening, that he allowed us to handcuff.
Okay. And after he was handcuffed, but when he was handcuffed, was it just you and Officer Dingle present?
Yes.
Okay. Once he was handcuffed, what, if anything, happened next?
He continued to argue with my partners, Officer Dingley and some other officers that were starting to show up. And then I focused my roles in completing the report and calling the sergeant because he requested a supervisor.
Okay. And at some point, was he arrested for account of obstructing a public officer
Yes.
and also for resisting a public officer or resisting arrest.
Yes.
At any point in time during your interaction with him or your continued visual of his interaction with other officers, did he cooperate with any of the officers present at the scene?
No, he kept shifting around, and normally we have people stand still in front of our car, and I could hear him arguing with the other officers.
Officer, are you able to see, there's not a screen over there, so I might have to bring mine over to you with the board's permission. Okay. Okay. Very loud.
Okay, so now what you're about to see is the body cam footage of the interaction. And in the body cam footage, you're not going to be able to really see the defendant back up. The defendant has video. He was video recording the situation. And it's earlier in this video, but I just wanted to focus on the court time. But if you go and watch this video and then look and see his own personal video that he made, you can see that when the officer tells him to back up, he actually does take steps back. He actually does back up. And that's very important in this. Now, they're going to play the body cam footage because the plaintiff submitted that as evidence, and so she could play it. The defense attorney, however, did not seem to submit his side of the video as evidence, because if he had, then that could have been played in the courtroom, and they could have proven that the defendant did in fact back up, but it was never shown in court that that happened. Everyone kind of just goes forward as, like the defense kind of goes forward as though it's a given that the defendant backed up, but it has never been established with facts during the actual trial, and that's a problem. This is the defense attorney, this is the defendant. This is the guy whose freedom is on the line right now, and this is the guy he hired to protect his freedom, but who failed, and I've accidentally fast-forwarded. I don't know how to...
Specific reason why it was suspended, and then you just have to correct it through them. But anyway, that's the reason why I'm going over. The registration case expired. Welcome. Don't engage my driver, back up. Hey, back up. No, we agree on that? No, I don't know if you'll be my business.
Now, oddly here, nobody seems to pay attention to the fact that the video just jumped forward. We just jumped forward from a point where the officer's telling him to back up, and possibly maybe we could have seen him on the body cam footage backing up, but the video just kind of jumped forward and nobody seemed to notice that.
I don't care if it's not reaching. There's no weapons on you guys. Stop, please. I don't care about the camera. Put your hand behind your back and not reach this phone.
And that concludes the 12-minute and 31-second video. The video marked 468 _ number sign 1.mp4. Officer, at some point after this interaction that we just saw, did you come to realize that your body-worn camera had accidentally or inadvertently turned off?
Yes.
Okay. And at what point in time did it turn off?
It would have turned off at the completion of the video that we just saw. Prior
Prior to what?
prior to the handcuffing.
Okay. Did you we noticed Officer Dingle show up to the scene though?
Yes,
Okay, and do you know whether he had his body worn camera turned on?
yes, it was activated.
Okay, and so what would have been missed by the inadvertent turning off of your body worn camera would have been captured on Officer Dingle's body worn camera?
Yes,
Okay. Then turn your attention now to the video labeled 416B .mp4, and okay, I just played the first 13 seconds. Now, for the record, the video is upside down. It recorded upside down.
Why would it record upside down?
ma'am, there's a setting in the application where you can rotate it. This officer may not have checked that beforehand.
Okay.
Stopping or starting at 4:54 timestamp on the video that we've been talking about. Do you recognize what's depicted, at least in this still portion?
Yes, this is me and DeCastro in front of my patrol vehicle.
Okay, and so to your knowledge, and after having watched this, does this fairly and accurately depict your interaction with the defendant on March 15th of 2023 as caught on camera by Officer Dingley's body worn camera?
Yes.
Move to admit 416 B or 8 and Q4.
No objection.
You know if it's an 8 or a B for sure?
It looks like a B too.
Okay.
Thank you.
3, I lose. All right.
Okay.
416B.mp4 will be admitted and published.
Thank you, and I'm just gonna start from 4:54. And may I approach you on that?
Can we move the water bottle so you can see it too?
Of course.
Thank you.
You can come up.
You can
Thank you,
do.
appreciate it.
Now, they've just informed the defense that they can come up and look at this. But you're going to notice that later on the defense says, or Chille talks about how he couldn't even see what happened, and at one point it's kind of silly because we could just watch it upside down and see what's happening. But the defense attorney, the plaintiff attorney actually picks up the laptop and holds it upside down while the video is playing, so it kind of confuses the whole thing. And that's a silliness that happened, but they got the video on the record in the hearing. The judge could see it, and that's really all that mattered. And it was on the defense to walk up and look at it and make sure that they could see it as well. But they didn't. It seems they just sat in their chair, and but then later claimed that they couldn't see it. And it's like, sometimes you have to take initiative,
Is there any way to rotate it so it's right side up?
I'll draw it. Just the video. Okay, there we go. This way.
Put your hand.
There you go.
I haven't done anything wrong. Put your hand behind your back. I'm putting you in handcuffs. So the prosecutor pulls up his laptop and she turns it upside down because the picture's upside down on her laptop. And then she's showing the judge the laptop, but we can't see it. My lawyer can't see it, I can't see it, none of us can see it. So she's presenting this video evidence, but we don't have a chance to rebuttal it. Mr. Me has not printed out any screenshots of the video showing I was standing here inside the line, and then a minute later I'm standing 3 feet back behind the line. So there's no printouts that show where I was standing once and where I was standing again a few moments ago. And then additionally, when the prosecutor is presenting this laptop to the judge, nobody can see what's being presented, so there's no way to object to anything. The only person who could see the video was the judge. It was a horrible presentation. It was a total kangaroo court. It was absolutely ridiculous. It's just so phenomenal that I'm in this freaking dungeon. And you look at the court case, the court trial, and it was just total crap. There's just no way I should be convicted of obstruction in this dungeon when, number one, I did not obstruct, and number two, I shouldn't have been put in jail anyway.
I'll just bring this way.
and he's right. I mean, he's right. He shouldn't have been put in the jail. They wanted to punish him for what he was doing and the way that he thinks. And he shouldn't have been put in jail. But you have to realize that you could have objected. At any point, the attorney could have objected. And when you hired that attorney, you gave up your opportunity to speak. You no longer could even speak on your behalf. You are considered a ward of the court. A child, basically, somebody too dumb whose words cannot be heard in the courtroom. It's on the attorney to defend you to the best of his ability. And that attorney, I mean, if this is the best of his ability, then there's no way that he should ever be selling himself as a trial attorney whatsoever.
So, officer, did the body-worn camera portions that we played, or that I played, fairly and accurately depict your interaction with the defendant on March 15th of 2023?
Yes, it did.
Concerning, I just want to talk with a little bit about what was depicted in the video. In the video from your body-worn camera, it shows, you know, the state of your stop with the Hyundai driver. Do you recall that?
Yes.
Okay. And at some point prior to you making contact with the defendant, you noticed him kind of recording further away from the vehicle, correct?
Objection leading the witness. These are leading questions, and they should never be allowed to happen in direct examination. If the defense attorney had said, objection leading the witness, then the judge would really have had no choice but to sustain those objections, and whatever his answer is to those questions would not have been admissible. And I just can't believe how many leading questions you're about to hear from Agnes Botello. It's just amazing to me.
Yes.
And at that point in time, you didn't have a problem with that. You didn't really approach the defendant yet, correct?
Correct.
It was when he started making contact with the driver, your stopped driver, that you approached him and asked him to back up.
Yes.
And at some point in time, in the video, it's recorded, you told him that he is allowed to record, but he just needed to back up.
Yes.
Okay. And what was the reason for you trying to maintain, one, the lack of no contact with the stopped person, and two, trying to gain distance between the defendant, yourself, and the stopped driver?
My first intention is I wasn't trying to delay my traffic stop any longer than it had to be. I was trying to make it as short as possible for the driver. And then the second was for officer safety. What we're taught in the academy is that for a normal human's reaction time with open ground, anything within 21 feet, that suspect would be able to charge an officer without them being able to react in time.
All right. And at that point in time, you were the only officer present, correct?
Yes.
Okay. And when he began, or when the defendant failed to obey your command to back up, that's when you decided to engage him?
Yes.
Okay.
When the cop got up there on the stand and testifying, he testified to this magical 21-foot rule that they taught him in the police academy, that people have to be 21 feet away from you or they can run up and stab you. Then he said that he didn't mind me filming, but at the same time, we had to observe this 21-foot rule that is completely a made-up fabrication in his mind.
And the reason the cop is saying we didn't mind him recording is because he already knows the defense is trying to use a First Amendment defense. Basically saying, well, this guy had the right to record and he shouldn't have been arrested based on the fact that all he was doing was recording in public, which is true. It's true. But the state is not saying he didn't have the right to record. They're saying he had to move a certain distance away, a reasonable distance, and that may not necessarily be 21 feet, but then the defense attorney actually has to step in and he has to point out the fact that, number one, the the defendant, Chille Castro, did follow the so-called lawful order to back up. He did follow it. And it was not specified how far he had to back up, but we can see in the video, assuming that he had presented the video that Chille took, then he could have argued that, well, he backed up. But instead, you're going to notice the defense attorney sort of tries standing on this, well, he had the right to record, but nobody is disputing that. They're admitting that. And so they're taking it away from being a First Amendment issue by saying, yeah, we acknowledge he has the right to record.
No statute, code, or ordinance that says that I have to be 21 feet away. And then even if I did have to be 21 feet away, and if he wanted me to be 21 feet away, then he has to give me what's called due notice and inform me, hey, I want you to be this many feet away over there. But he didn't do that. And then additionally, when he testified, he said that I didn't step back. Well, the video evidence shows that I did step back. So he just lied the entire time he was on the stand.
The video evidence that was presented in the courtroom, however, did not show that he stepped back. If he had shown his own video that he had stepped back, then he could say that. But he can't say it because the court can only consider the facts that are presented.
I have no more questions for this witness. Thank you.
Good morning, officer. How are you doing?
Okay, so now, Michael Mee, the defense attorney, has the perfect opportunity to paint the picture of what happened by using effective cross-examination. And effective cross-examination is leading the witness. You know, isn't it true that you asked him to step back? Yes. And he did step back, didn't he? And, well, he stepped back a couple inches. Well, that's stepping back, right? Well, it was only a couple inches. Can you please answer the question? It's a yes or no. Yes, he did step back. And if he had done it in kind of that way and established from the witness's own mouth, you know, after he paints the picture, leading the witness, and he eventually has to get the yes, or else the officer is obviously perjuring himself. Now he also has to have the video evidence to substantiate that, to make it so the witness will say yes. You know, and you'll notice the witness even does waffle a little bit and admit that he might have stepped back a couple of inches, but that's stepping back, you know? And if somebody's given an order to step back, and they step back, you know, half an inch, that's still stepping back. You can't put it on the defendant at that point to be able to read the police officer's mind to determine that the police officer wanted him to step back 21 feet. All you show is that he did follow the order. He stepped back.
Morning, Mr. Arnwell. How are you?
Very well. How many feet did you order the defendant to back up specifically?
I never had an opportunity to give him an exact distance.
How far back did you?
See, you didn't order him to step back a certain number of feet, did you? No. It would have been a much better question than what he actually asked. You know, a defense attorney, cross-examination, you always are asking leading questions. One fact at a time.
You intend to have him back up even if you didn't express that?
In the background of the video, you could see that there was a parked semi-truck and a light pole. I would have directed him somewhere in that area, which would have been outside the 21 feet.
Your testimony is you never told him an exact distance to back up, correct?
Yes, he never allowed me to.
What do you mean you never allowed you to?
I asked him to back up, and he continued arguing with me, so I could never specify the exact distance for him.
See, so when the defense attorney asked, what do you mean he didn't allow you to? Like, you should never ask that question. You're opening the door for the witness to look very credible and say what he just said, and he just looks more credible in front of the judge. And as a defense attorney, you should be painting the picture and forcing the guy into yes or no questions to make him look bad, right? but the defense attorney seems to have no clue of this. And so every time he asks a question, a very broad question, and just gives the witness the mic, then the witness is going to take advantage of having use of the mic and always bring it to the issue of safety. And it's always going to look like the officer only has safety on his mind, when if the defense attorney painted a good picture, then they could show that maybe safety wasn't the only thing on the officer's mind. And the defense attorney tries to show that in his questioning, but the way he asks his questions is so terrible that it only makes the witness look better and more credible.
But you had time to give him 5 commands to back up, is that correct?
Yes,
Your testimony is he never backed up when you were giving him commands, is that correct?
if he backed up, it may have been inches, but he didn't substantially back up.
And you just reviewed the body-worn camera from your chest, is that correct?
Yes,
Okay. You didn't notice him backing up every time you directed him to back up?
he did not back up.
So you backed up 0 feet, in your opinion? Based on that video?
Not 0 feet.
What was that?
He didn't back up 0 feet, he was moving his feet. As to exactly how far he moved back, I don't know.
Okay, so here's a perfect example for the defense to destroy this witness, because the witness just admitted that, well, yeah, he did actually back up. It wasn't 0 feet, he backed up a little bit. Oh, so he was following directions, right? Well, no. Well, hold on. Didn't you just say that you told him to back up, and then he backed up some distance, correct? Well, yeah. And the witness is obviously going to try to talk his way out of it, but if you just keep him to yes or no questions, yes or no. Yes, did he back up? He backed up, right? Yes. Finally, you get that yes, and then you just move on. But this defense attorney does not know how to do any of that.
It wasn't substantial.
What would have been substantial in your opinion, or what do you mean by that?
It's too open of a question. Now you're allowing the officer to answer however he wants to, rather than just saying yes or no to your leading questions, and it's just making the defendant look worse and worse.
I would have guided him if he wasn't arguing with me back toward the light pole in the park semi-truck.
And
Would have been outside of the 21 feet. That was my goal.
So in your opinion, you have the ability, or you would in any traffic stop, ask somebody to move back 21 feet, is that correct?
Yes, for our training,
And what was that training?
that while we're conducting lawful activity, we're allowed a reasonable distance to conduct our activity.
But where do you get that 21 feet number from specifically?
That's taught to us in the academy. It's based on reaction time, normal human reaction time to a threat.
So your position is anytime you're engaged in any law enforcement activity, you would create a 21 feet perimeter?
Not necessarily, it depends on other environmental factors such as obstacles and barriers.
So your testimony is that every time you conduct a traffic stop, as long as there's no barriers, you would order a pedestrian to back up 21 feet, is that correct?
I would, yes.
What training do you have in regards to the First Amendment?
It's standard academy training.
Can you explain what that entails?
So here's another open-ended question, and what it's going to lead to is objection relevance, because nobody is saying that this guy didn't have the right to record, but the defense is inept at showing that this officer got triggered because he was being recorded and because the guy didn't just automatically follow his directions. And if Chille had done all of this in a more effective way, he wouldn't have been arrested, and he would have made this guy look very embarrassed. But he just didn't. He didn't. Because Chille is still sort of trying to stand on the so-called law, and he's not looking at it logically, and he's not approaching it from a logical standpoint.
Usually includes a classroom setting, PowerPoint taught by police officer, academy officer.
Do you remember receiving that training specifically?
Yes.
How long ago was that?
When I was first employed about 8 years ago.
Do you have any follow-up training?
Specifically on First Amendment, we've had some follow-up training regarding First Amendment auditors.
Okay, can you explain what that follow-up training was?
The follow-up training was just a refresher on the First Amendment and how the department wants to handle or react to First Amendment auditors.
In that training, did they explain any case law governing how many feet somebody has to move back or anything like that?
Objection, Your Honor, at this point, of relevance. I think it's beyond the scope of, the charges that you are to determine guilt on at this time.
Can you tell me what's the relevance?
Yes, Your Honor. He detained the defendant after issuing commands back up a particular distance. He's testified he's received training. I should be entitled to cross-examine him about what that training is and how he's coming up with the specific numbers he's using to
I
issue.
think her objection was with respect to the case law that you're inquiring about.
Your Honor, our position is if he is issuing commands that are contrary to that case law and he's been trained on that case law, then there can't be an obstruction of justice.
So I'm going to sustain the objection and ask you to move along.
Have you had any prior issues enforcing the First Amendment?
No,
Prior to this event taking place, had you heard of Jose DeCastro?
no.
Do you recall when you first heard about First Amendment auditors specifically?
Go for it.
It would have been in the academy.
So that was when you were first trained? You had heard about the auditors back then?
Yes, when we were learning about the First Amendment, they would typically bring up issues that might be a frequently seen thing, and First Amendment auditors are typically the ones that we encounter when there's First Amendment claims against us.
So it seems to me that Mr. Me is attempting to establish that there might be a bias in this cop's mind, but he never articulates a factual basis for how that bias exists, and he never reveals that his cross-examination intends to discover that bias or find that bias. So it's kind of like Mr. Me is just sort of sloppy in that he thinks that he can ask these questions and try to get at this bias, but he doesn't really know how the facts get into the ears of the judge. It's like he doesn't understand how to present facts, and it's very sad to watch.
Do you have any belief that First Amendment auditors are likely to be violent?
Objection, relevance.
What's the relevance?
Uh,
I'm only concerned with Mr. DeCastro. Okay?
And now would be an excellent time for him to point out the bias against Castro, because the judge is basically opening that door for him now, but he's not even going to walk through it to establish the bias. He's just going to kind of fumble.
Your Honor, one of the legal issues at question here is whether or not these commands are reasonable. I think that has to be based upon his past experiences in training.
Sustained.
During this traffic stop in particular, what specific factors led you to believe there might be a danger to officer safety?
Based on his proximity to my driver,
Another open-ended question that completely just helps the plaintiff. Please describe for me how this situation, or what this situation had to do with officer safety. And it's like, you don't want to give your witness that open door to just say whatever he wants in that situation. You should only be asking leading questions, and they should be yes or no questions, and you limit the witness to yes or no to the questions that you ask. It should be that simple.
based on his demeanor being argumentative, based on his physical demeanor, his veins were popping out of his neck as he was yelling at me.
See, and you just got the witness to now paint the story. You got the witness to paint the picture, when you as a defense attorney should be painting the picture and putting the witness in a very uncomfortable spot. But he just doesn't know that that's part of the game. He doesn't know how to play like that.
You can see his veins popping out of his neck from your back where your vehicle is.
When I was at the
Yeah, and then to ask the question, let me have you reiterate that yes, you could see his veins popping out? Yes. And the witness looks completely reasonable, even though he's lying his ass off.
driver's side window, I could see that, but not in my car.
So when you see him walking out from your car, what is your specific concern regarding officer safety at that point in time?
Well, it's my safety and the safety of the driver. I don't know who this person is. I've never met him before. He could be peaceful, he could be violent, I just don't know. There's so many unknown factors. And I also have a responsibility to protect that driver. If I were in that driver's position, I wouldn't want to be approached by some random person recording me, interviewing me.
Did you ever ask the driver their opinion about whether they wanted him there or not?
No, my first step was,
Relevance.
Sustained.
Was your primary concern him speaking to the driver or him not backing up allegedly?
my primary concern was safety. I don't know if he was armed or what his intention was.
Do you presume someone is armed and dangerous just because they're in public?
I can't rule out that he's unarmed.
But you had no reason to believe he was armed on this occasion?
No, nobody had told me he was armed, and I didn't see any weapons visible, but he was wearing clothing that could have easily concealed weapons.
You stated your belief that the driver was entitled to privacy,
I did say that.
and what do you mean by that?
Instead of continuing to give him commands to back up, I said something different to try and help him understand. She's really not entitled to privacy, but she's entitled to safety.
So your explanation is that you said that because you were just trying to convince him to back up, not because you believed?
Yes, if I continue to give the command to back up and he's not listening, I can't expect something different to happen if I just keep saying back up.
In your police report, do you recall referencing the fact that he had due notice in your opinion of what you were commanding him to do?
Yes, when I gave him 4 commands to back up, those do notice.
Okay. But you'll agree with me, he did not have notice as to the distance you wanted him to back up, is that correct?
That's correct.
The crime of obstruction is clearly outlined in the Wilson case, and I was not obstructing. You didn't get due notice and tell me I want you to back up 21 feet. You just asked me to back up.
Approximately how long were you issuing these commands to him before you decided to take the defendant?
Approximately 15, 20 seconds.
And your testimony is you didn't have any time during the entire back and forth to tell him a specific distance to back up to?
Not time, but no opportunity.
How so?
Well, every time I tried to speak with him, he would argue he wasn't listening at all. So if he's not understanding back up, how would he explain something that was more complex?
Well, what was preventing you from saying back up to a particular location?
First, I would want him to back up, and then if he didn't back up far enough, I would give him an exact location.
But you never.
Can you see how the defense questions only help the plaintiff? Because the way the witness is answering them, he's just giving more of the story and painting more of the story and painting this guy out as though he just didn't listen at all. He didn't give him the opportunity to even say, hey, it's 21 feet, I need you back. Like, the witness is making the defendant look really bad, and it's all because the defense attorney is asking questions that allow the witness to answer and make the defendant look bad. It's like, it would have been better if this attorney did not cross-examine. If this was the way that he was going to cross-examine, it would have been absolutely better for him to not get this additional testimony on the record. And wow, it's just, fuck, dude.
Never did, correct?
No, I never did.
Did the defendant's verbal comments towards you influence what you decided to do that day?
No.
On the video, did you see that the point in time you decided to detain him was specifically after he made an insulting comment towards you?
That wasn't why I chose to detain him. I realized that he wasn't going to back up at that time.
His comments didn't make you
See,
angry.
and that's when it should have been like yes or no. Like, it's not that you give him the chance to explain why, or explain that that wasn't the reason, it was just safety. You don't give him the chance to explain why. You say, hey, move to strike because that wasn't a yes or no. And then, can you please only answer yes or no?
At him.
No.
In your review of the video just now, he had both hands in front of him the entire time, is that correct?
No, at one point he reaches toward his back pocket to pull out his second phone.
Did you quickly see that it was a second phone he was going for?
Yes.
Okay. So once you see him produce the second phone,
And you saw it was only a second phone that he was reaching for, right? It wasn't a weapon, correct? Yeah. So it was only a phone. Yes. Okay. So there was no additional danger posed when he was reaching, right? Because you saw that it was just a
in his
phone,
hands.
right? Yes. That's how you cross-examine in that situation. But this defense attorney has no clue how to do that.
He's obviously not reaching for a weapon, is that correct?
At that time, no, he wasn't.
What time of day did this occur at?
If I remember correctly, I think it was around 4:30 in the afternoon.
And this was in a broad public place.
Yes.
Does the fact that this occurred in broad daylight in public influence your decision-making as far as issuing commands to the defendant?
It could. In this particular case, it didn't.
And why is that?
There was nobody around us other than me and the driver and DeCastro.
You testified he swatted your hand away, is that your testimony today?
Yes, that's the best way I can describe it.
And you saw his arm do this, or you just felt it?
I saw it and felt it.
Do you recall in your police report stating that you did not believe his intent was to harm you?
Yes, I wrote that.
And what is your basis for reaching that conclusion?
Well, he could have been charged with battery on a police officer, which would have been more severe. But I didn't think.
You see how damaging that question was? Well, he could have been charged for battery, so we're cutting him a break by charging him with a lesser offense, because I made the wise determination that he wasn't trying to batter me, that he wasn't trying to harm me. All he was doing was obstructing, which just solidifies the guilt in the mind of the judge. And it's just very poor what this defense attorney did to this guy.
His intent was to hurt me, so I didn't charge him with that.
You testified today that one of the things you were concerned about was him not going over to your vehicle, is that true?
Yes.
Will you agree with me that he actually did walk over to your vehicle at some point during the interaction?
Yes, but it wasn't reasonable, the amount of time it took him.
What would be a reasonable amount of time?
Asking him to step in front of my car and then doing so immediately.
And how fast is it immediately?
This isn't based off of time, my response, it's just based off of interaction. I had to tell him he was detained multiple times. And I made it clear what he was detained for. I said he was detained for obstructing. And I gave him several commands to step in front of my car. So I would think a reasonable person would walk over to my car, and then we'd have a conversation there.
And how specifically did his presence obstruct your ability to complete the traffic stop?
Again, I don't know what his intention is. I don't know if he's armed. All I saw was him reporting, which, again, I had no issue with. I told him I had no issue with. At some point in time, if I were to issue a citation to the driver, my focus would be on the driver and what's inside her car. At that point, I hadn't pulled her out. I hadn't pat her down. I don't know if she has any weapons in the car or what her intent was, if there was anything underlying. So my intention on having DeCastro back up was so that I didn't have split attention. He was too close for me to have split attention.
So what are the things you stated that you were concerned about, I guess, from a safety point of view, was that he didn't identify himself? Is that true?
No, I didn't care about his identity until I had him detained.
At any point during the detention of the defendant, did you pat him down to determine he didn't have any weapons?
I did.
Okay, and when was that during the duration of the interaction?
That was immediately after handcuffing.
Okay, did you discover any weapons on him?
No, I did not.
From your police car, while he's walking up, you can essentially have a complete view of his movements and what he's doing at that point in time.
Yes.
And you never saw him during that time period before you got out of your car and reached for any weapons or anything like that?
No.
Were there other individuals around the traffic stop other than the defendant and the driver?
Not that I can remember.
Do you recall anyone walking through the scene and asking about the restaurant next door?
I don't remember that.
But your testimony is if there was someone else on the video, you would have been ordering that person to back up 21 feet?
I would have first asked them to back up, and most people do. And then if they did not comply, then I would give them a specific area to back up to.
You ordered him not to speak to the driver, is that correct?
Yes. Well, I remember asking them to back up. I don't remember if I specifically asked them not to speak to the driver. I think I may have said don't talk to her, or something to that effect.
Did he speak to her before you got out of your patrol vehicle or afterwards?
Before. I saw DeCastro filming, I stayed in my vehicle and continued my business. Then when I saw him speaking to the driver, that's when I exited.
Did you see him speak to the driver after you exited the vehicle at any point?
I don't remember if he spoke to the driver after I exited.
At any point, did you hear specifically what he may have said to the driver?
No, I was too far away and it was windy.
Is your position that anytime you're engaged in a traffic stop, nobody can speak to the driver?
They can speak to them at a reasonable distance.
And is that 21 feet?
It could be shorter, it could be longer. Again, depends on the environment, totality, the circumstances.
Do you think people can easily verbally communicate at 21 feet?
No, not without shouting.
Did at some point the defendant inform you that he was a member of the press?
He did.
Did that influence any of the orders you chose to give or not give to the defendant?
No, it doesn't matter.
Why does it not? What is your basis of that statement, I guess?
Media, reporters, and standard citizens, they treat them all the same.
So you becoming aware that somebody is a member of the press does not affect your decision-making in reference to your First Amendment training?
No, and how was I to know that he was a member of the press? Whenever I interact with members of the press, they usually identify what station they're with or a group that they're with. They usually have some sort of identification, name badge, and we have a good relationship with press out here. They don't approach us the way that DeCastro did.
Are you familiar with the difference between traditional press or independent media?
Yes, but again, independent media would approach us more respectfully than DeCastro.
Is your opinion that traditional media has different rights than new media, independent media?
Objection, Your Honor. At this point, I think we're well beyond the scope of.
Sustained.
Thank you.
So your testimony is, if I recall correctly, that you received First Amendment training when you initially went through your officer training.
Yes,
And then you received one follow-up after that.
I can't, no, it was more than one. I don't know exactly how many. Typically that training is annual.
And your testimony, just to reiterate, this is the first time you've experienced a First Amendment issue of this nature in your career?
Objection. I believe I objected to that question when it was posed as a violent encounter and it was sustained. And I also objected on the grounds of relevance. As the court indicated, what we're concerned about is his interaction with the defendant specifically. And so I object.
Sustained, only concerned about this interaction.
Do you recall during your interactions with the defendant that you told him that you believed First Amendment auditors often pull out guns and shoot people?
I didn't say that they often do that.
Do you recall what you said?
I don't. I would have said that he was a stranger to me and that officers get ambushed all the time. It could have been a First Amendment auditor. It could have been a regular citizen. It could have been a cook from one of the places nearby. I wouldn't have specifically said that First Amendment auditors are a higher risk.
What kind of bozo clown world are we creating in this country? That cops are scared of guys with cameras. It's ridiculous. And also, according to the LVPVA, the videos on YouTube by the Las Vegas Policemen's Protection Association, which are created by the district attorney, They've been taught about First Amendment auditors. He's not supposed to touch me.
And again, just to reiterate,
See, but they're not talking about the First Amendment auditing thing. They're talking about the safety. They're not contesting that the man could do a First Amendment audit, meaning he can record. They're saying he had to record from a certain distance away. And when you don't put this together and like obliterate the plaintiff's argument as the defense attorney, when you don't do that and you're just all over the place, like trying to jump from one thing to another, it's like you're scrambling for and hoping for the witness to screw up. And you, as a defense attorney, you should be asking leading questions that make the witness screw up. But he's not doing it. He's just giving the plaintiff more to work with, and it's sad to watch.
your testimony is that
Objection, I mean, anytime it's prefaced as just to reiterate, I feel like I should object on an asked and answered ground, and I'm not, just to hear it, but it just sounds like a reiteration of the question that I've previously asked, so my objection is asked and answered.
I'm going to ask this question before I rule on your objection.
again, I'm just trying to clarify because I think this point was ambiguous, but do you recall the defendant telling you that he was a member of the press during the interaction with the defendant?
Asked and answered.
Sustained.
It's like the defense attorney is just falling right into their trap, and it's almost like this is like the actual hustle, right? Because how much is DeCastro paying this attorney, right? And this attorney he collects the money, or if the attorney's a public defender, he's gonna collect the money anyway. So who is he really helping? Like, is he just scamming this guy to say, hey, I'll defend you in this trial and give me the money? And it's like, the lawyer doesn't have to go to jail. DeCastro goes to jail. So you really, like, I see a lot of people paying these attorneys a lot of money. Like, holy shit, it's quite a bit of money. And it's like, and then the attorney is just like throwing them down the river, like just throwing them under the bus. It's like, because he can, and because the defendant generally won't be smart enough to see what happened, right? So it's just crazy how this system works.
No further questions, Your Honor.
You direct?
No, thank you.
Thank you, officer.
Yeah, notice how the plaintiff didn't want to do any redirect. It's like, nope, don't need anything else. I've got all that I need. The defense attorney helped me with him. And you're going to notice she does the same when DeCastro goes up and testifies. She's not going to ask him there's not going to be any cross-examination of DeCastro because she knows that part of the element of proving this case is she has to prove willfulness, that DeCastro willfully obstructed or willfully disobeyed an order. And it's obvious that Castro didn't willfully obstruct, but they can make it seem like he did, and as long as the plaintiff doesn't help any of that come out by cross-examining him and then getting answers to questions that answers that she doesn't like, so it's all a game. You gotta know how to play the game. You have to at least look to see and understand how the game works, and if you're gonna be an auditor, whether you believe in the Constitution and want to do it as a First Amendment audit, or if you want to audit it from a logical standpoint and audit, how they deal with people who challenge their authority, you should be familiar with at least how the court situation works, so that if you're in DeCastro's seat, you can at least see it more clearly and hopefully end up not in jail.
You may stand down.
Thank you, Your Honor.
Officer.
Can't I have an anti-arraignment, please?
Is the state rest?
At this point, we do.
I'm triggered already, so I do a horrible job as well. When I go on the stand, I didn't testify what I was normally testified to. My lawyer hadn't submitted my video into evidence, so there's no breadcrumb for me to follow. There's no trail for me to follow, or I would have gone into some legal theory of I have a right to be there. It's just messed up.
Does the defense have any witnesses?
Your Honor, I call opposing DeCastro.
No.
He shouldn't have even taken the stand. Like, unless they have a very clear plan on how to make him look a lot better, he should not have taken the stand. And he shouldn't have been triggered. You should always be prepared for court, and there's no reason why not to role play the situation. And you know, I'd really like to role play with people who actually want to help themselves in court. But it's hard. They're few and far between, the people that actually want to help themselves.
Raise your right hand to be sworn by the clerk. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please be seated.
Mr. DeCastro, before you testify, I'm obligated to inform you that you have the right to testify in this proceeding, but you also have the right to remain silent. And should you choose to remain silent, I may not hold that against you in making my decision. Do you understand that?
I do.
And do you still wish to testify?
Yes, I do.
All right, please go ahead.
You have a YouTube channel?
Yes, I do.
Can you give some insight into what that channel was about?
Objection, relevance.
What's the relevance?
Your Honor, the relevance is that we're presenting a First Amendment defense, and the defendant is a member of the press. There's different standards for First Amendment rulings where there is public policy at issue. He can give insight into that.
I'm going to allow it for a bit and see where it goes.
Yes, I do have I do have a YouTube channel, and the reason I have a YouTube channel is because of how many cops kill people every year, how many cops hurt, maim, torture, rape, and kill people every single year. It's such an epidemic that the rest of the world, I get thousands of emails saying only in America.
So he should be playing to the judge. And the problem with what he's doing right now is he's trying to be heard. He thinks, oh, this is my time to be heard. This is when my point is going to come across. And it's like, no. Your job right now is to convince the judge. And all you're coming across to the judge is just, we need to punish this guy and just show him why he shouldn't continue to do this. And, you know, you go in thinking that you're going to be heard and that suddenly you're going to have a platform now to say something really righteous. And it would be nice if that was the way it is, but it's not.
Does this happen? I started filming cops because when I was cheated in 2002 and
Objection at this point, relevance,
this is the reason I'm a member of the press.
this narrative.
So can you ask him a question?
Yes, Your Honor.
Now, I might be wrong, and I haven't looked it up. I'm just talking as we do this. I believe that narrative would be in cross-examination, or it might be if the attorney was asking a question that explained a lot of things before actually getting to the question. That would be narrative. I don't think that this was actually narrative, but I think that she said it, and the defense attorney didn't argue against it or rebut it. And so it's just like it's something that kind of is sort of heard, but it doesn't get deeply analyzed to say, oh, this isn't narrative, this is the witness giving his direct testimony, which he can do. Because right now Michael Mee should be asking him direct questions, and he does. He doesn't ask him leading questions like the plaintiff asked her witness leading questions during direct examination. But it's also, he should be asking these open-ended kind of questions and giving the witness the opportunity to bring forth facts. And narrative isn't really something that you should, that shouldn't be an objection at this point, because the witness is laying out the facts, and he is still answering the question.
What type of films do you make for your YouTube channel?
I only film police in their official capacity. I'm known across the country and across the world.
And why do you engage in that type of filming?
So I'm going to ask you, Mr. Mead, to direct your questions about the incident in question.
The reason I was filming Mr. Vort that day,
Objection, Your Honor.
Oh.
Oh, I'm sorry. There
So,
wasn't a question posed, so
Oh, I-
I'm not sure what he was.
Mr. DeCastro, on the day in question, why did you approach that vehicle?
I was filming that cop.
See, and this is a situation where that whole exchange with the judge and the plaintiff attorney, it sort of put me, Mr. Me, in a situation where, oh yeah, I'll go ahead and ask that question. But it was a question that they set up for him. They set him out to ask that question, right? So who's controlling the frame at this point? The defense attorney should be controlling the frame of everything at this point. And he should be exhibiting his witness as a credible person, giving credible testimony. But he's allowing these, the judge and the plaintiff attorney to sort of tell him what to do next. And it's gross. It's disgusting that he just falls right into the trap because he's such a weak attorney.
Because that's what I do for a living. I am a member of the press, and I invoked my right to be press. I always invoke my right to be press within the first 10 seconds of engaging with police, and I have thousands of videos that prove this.
so this is how you make money.
This is not how specifically I make money. I make money from selling legal documents to people.
Okay.
Look at the judge. Bring it to so this is how you make money. And it's like he's coming across as self-righteous. And it's like the judge isn't hearing him. She's just trying to make him look worse and worse. And it's like, no, I make money selling legal documents. So now he sounds like he just sounds like a fucking car salesman or somebody who sells people things that they don't really need to be sold because they could find any legal document online. They could write their own legal documents, but he sells legal documents, you know, and it just makes him look bad.
Go ahead.
Do you recall the officer telling you to back up?
Yes, I do.
And what did you do after he told you to back up?
I took a couple steps back. I just showed him that I was willing to back up a little bit. However, if I may, in Arizona, they created a 10-foot law.
Objection, relevance, we're not in Arizona, it's the state of Nevada.
So I'm going to allow it because I think that goes to why he kept saying 10 feet in the video, even though I will take judicial notice that you're not in the state of Arizona, you're in the state of Nevada.
Well, a federal judge struck it down, Your Honor, and
Stop. Can you ask him a question?
Yes, Your Honor. Approximately how many feet did you back up?
I backed up a foot or two. I was at least 10 feet away from that car that the driver was pulled over in.
And when you spoke to them,
See, in asking him approximately how many feet did you back up, it's like, it's a poor question, because if he answers the truth, which is like 1 or 2 feet, it makes him look bad. It's like, you backed up, correct? Yes, I did back up. You don't have to get into how many feet it was. All you have to get into is he received a so-called lawful order to back up, and then he backed up. The distance doesn't matter. He followed the direction, didn't he? Or else, did he not? Well, officer already said he did back up a little bit. It wasn't to the officer's standard, but the officer didn't outline his standard. So, all that matters is he did back up. But it's never proven, right? All it is this guy's testimony, and he seems uncredible to the judge because of his attitude.
the driver, what did you say?
Just asked her if she was okay. The reason I film police is because they abuse people so often.
Do you recall the officer telling you not to speak with the driver?
Yes,
And did you make any statements to the driver after that command was given?
absolutely not.
Did the officer ever give you a specific distance to back up to?
No, he didn't.
If he did, would you have complied with that?
Sure,
Did you believe you were complying with the officer's commands?
100%. I also informed him I'm a member of the press, I'm a constitutional law scholar, that this is what I do.
Do you recall the officer explaining to you why he decided to arrest you?
There's several parts to the reason why he said he was going to arrest me. He said he was going to arrest me because I wouldn't turn my head a certain direction. If I didn't turn and face the car with my head, that he would place me under arrest instead of just giving me a ticket.
Do you recall him?
See, and now he's sort of over-dramatizing a situation that he was in. Because by this time, he was already at the police officer's car, and the police officer had him, like, in handcuffs and stuff, or was trying to handcuff him. So he had him obviously in custody, and he's like, face the car, and it makes him seem like he resisted, or he didn't do the thing that the officer asked at that point, because at that point it's like, if you're going to allow yourself to get in handcuffs, then you may as well just face the car. Like, it's not that you, the officer threatened to put you in jail because you didn't turn your head a certain way. It wasn't like that. It was like, you're already under arrest, you're already in handcuffs, and now face the car so that I can have better control of you, which the officer can always say, that's for officer safety.
Explaining why he decided to detain you before he arrested you.
He decided to obtain me because he said I was obstructing, which, from my understanding, is a physical act where I would have to get in the way. He said that the driver deserves privacy. I believe my First Amendment rights are not up for feelings.
See, and now, he can say that, but because he doesn't have the judge on his side, she's not going to hear it. Now, if the defense attorney had used leading questions to ask the police officer, isn't obstruction a physical act? Yes? Yes. Okay, so, and my client didn't do anything to physically obstruct you, did he? No. You know, and see how you can paint the picture as the defense attorney asking leading questions, but if you don't do that, then all you have is his word against mine, and she's obviously going to take the officer's word as canon, as what actually happened, because that's the guy that is so-called authorized and wears the badge.
Did he explain to you that the basis of your detention was related primarily to the issue of privacy or the issue of you backing up?
Well, I think from the officer's testimony, we can see that he's scared of the driver, scared of me, scared of everything. They teach them to be afraid of everything. So I had 2 cameras out. It's identified as a member of the press. I'm sorry, repeat the question. I want to get it specific for the record.
Sure. The question was, did the officer explain to you that the basis of your detention was because of you not backing up or because of the privacy issue of the driver?
It was both. He said that, he told me to back up. I backed up a little bit. Then he said, she deserves privacy. And then I told him to go get in your car, little doggy, and write your ticket. And at that point, his face turned beet red, and his veins in his neck stuck out because we were over 20 feet away. And you had to holler.
See, this guy literally wants to go to jail. There's no doubt about it. He wants to go to jail because all he's trying to do is get his little digs in during the court hearing, and I don't see how he could think that that would actually help, because it doesn't help him at all. It's like the judge doesn't want to hear you talk about how you called him a little doggy, so you shouldn't really testify to that. Just testify to the facts that you can prove, and your defense attorney should have had the video that you could use to help prove these facts, but it never happened.
To hear each other because the wind was probably 30 miles an hour.
Did you at any point attempt to hit any of the officers involved?
No, absolutely not.
Did you intentionally swat at any of the officers?
Absolutely not. He was giving me unlawful commands. I should not have been detained after I identified as a member of the press.
How do we know these were unlawful commands? You haven't set that foundation. You haven't established that as a fact. So how do we know these were unlawful demands? If you've never established that as a fact, then when you say it in your testimony, that which is asserted without evidence can be dismissed without evidence, and the judge is dismissing that. She's not using it or taking it as a fact. And so you're just wasting your breath.
If he ever reached a hand out towards me, I wrestle and teach MMA, and I have for 30 years. So it's just a natural reaction as I'm retreating from somebody. If I may have put my hand up, as he said, as he testified himself, I certainly am a law-abiding citizen. I don't break the law. So I would not have tried to assault an officer under any circumstances.
Is it possible that during the interaction there was inadvertent contact between you and the officer?
Sure, he decided to go hands-on with me when he was giving me unlawful commands. And there was absolutely no reason for it. I was wondering.
How do we know these were unlawful commands? There's no foundation. There's no foundation that these were unlawful commands, because you, as the defense, has not has not shown facts that would show that these were unlawful demands, and it's just, you're wasting your breath.
To comply with anything he asked within reason, because I don't want to have a fist fight with another man on the street.
Do you recall the officer ordering you to go to his patrol vehicle?
I do.
And what did you do in response to that?
Initially, I told him no, but then when he began to get physical with me and start to grab me and touch me, I said, okay, I'll go over to your car. His car was 35 feet away. I then led him to his car. It's on video, you can see it. I would walk right up to his car, and then he insisted still on grabbing me. After he saw me pull out an additional phone.
It's on video and you can see it, but guess what? That video was never submitted as evidence. Your attorney was ineffective counsel, and I know that you know that by now because you hired an appeal attorney who showed you that was ineffective counsel, but people have to see this attorney. That's what's called ineffective counsel. And if you have an attorney like this, you can sue your attorney after the fact, as long as you can show that you most likely would have won the case were it not for this attorney's mistakes. And I think that you could make that case here, that this guy could have won, but, you know, he's also not letting his ego be out of it. He's trying to put in his ego where he can. And it's like, there's no room for ego in any of this. You have to defend yourself effectively. And I'm sorry to say, but if you're still relying on the Constitution to protect you, and you're thinking in terms of that as being a fact, then your ego is still in the way.
Which, that's what press people do. We have lots of cameras on us.
And did you inform the officer that you were a member of the press?
Oh, several times. It's in the transcripts. I've transcribed them myself. Several times I told him I'm a member of the press.
And did you explain to the officer that you have a background in constitutional law?
Yes, I told him I'm a constitutional law scholar, which was a moniker given to me by other people who are also, they have their own channels, their own press, and that's what some other lawyers on another channel called me 3 years ago.
See, and that just sounds silly. That sounds silly. To say that you have a background in constitutional law because some people that have channels in a group 3 years ago said you're a constitutional scholar. Like, I've been accused of being a constitutional scholar, even though all I've done is challenge the factual basis of their claims. And they tried accusing me of being a constitutional scholar, and that's just somebody who's studying the Constitution. It's not an honorable title. It's not an honorable thing. It's not anything that the court will respect. It's just a thing that got into his head because he learned something new from those people. And those people said that about him, and so he went and ran with it. And he doesn't see the, pardon my expression, but he doesn't see the big dick on his forehead. And that's the problem.
And I sense that.
Like, he's even wearing a pin of the American flag, as though, I don't know, a lot of you guys don't like me because I don't agree with the American flag because I think it's worn by a lot of terrorists. And I think that in some foreign countries, it's like the last person that they see is a guy with that flag on his uniform, and that guy is the one that ends up killing him, and they think of him as a terrorist. Like, it's he, as long as you're clinging to false authority, you're fucked. You're not going to have a clear mind. And you can see how it affects your mind if you look at people like this guy attempting to testify on his own behalf, and you can see how the belief in the system and the Constitution and all that, it's affecting him, and it's putting him in danger, and he doesn't even know it.
The moniker.
And just to get some, I guess, further background, were you looking for police to report on this particular day?
No, the cops hide on the side of the road to pull people over. It's pretty regular in our country. I was just in the parking lot there. I saw that Mr. Bork had somebody pulled over, concerned for her safety. I began to film.
And why do you think that law enforcement traffic stops are relevant to the public?
That's where most people get killed.
What kind of question is that? Why do you think that police on traffic stops are relevant to you? Like, what? Yeah, that's just a silly question.
Relevance to that question, who should strike?
State,
I'll pass the witness, Your Honor.
state.
I have no questions for this witness.
And then he goes from there to, I'll pass the witness. Like, you can tell this attorney is so over his head, and it's just disgusting. He's like, okay, I'll pass my witness at that point. Does he think that the plaintiff is gonna now do cross-examination that's gonna harm, or actually help his case? Like, no, never in a million years. In fact, this prosecuting attorney actually takes a very smart move not to cross-examine this witness, because she knows that that could open the door for her to look bad and for her questions to seem silly.
Thank you, sir. You may step down. This is defense rest.
Yes, Your Honor.
All right. The argument by the state.
Your Honor, the state has.
Now, take notice of the judge's body language. Take notice of the difference in her body language right now as the plaintiff is giving their closing arguments. Look at the judge and look at what she's doing. And then when the defense is giving their closing arguments, take a look at the judge and see what she's doing then, and you're going to notice a difference.
You find the defendant guilty of both the obstructing a public officer as well as resisting a public officer charged against him. The video very adequately portrays, and I don't think it's disputed by the defendant, what the context was of the interaction with the officer. I would venture to say that had the defendant just complied with the original order to not engage with the driver and to back up, we wouldn't be here. He wouldn't have found himself further engaging with Officer Bork. This is not a First Amendment issue. As you heard over and over and over again on video, Officer Bork did not have a problem with the defendant recording. It's not a First Amendment issue. It's an officer safety issue. Here you have an officer who conducted a lawful traffic stop.
The judge is looking her in the eye. The judge is looking right at her, hands crossed under her chin, just looking at her. And she's probably thinking in her mind, damn, this girl's good. She's a good attorney and she has a future ahead of her. And those are probably the thoughts going through her head. She's just admiring this young attorney because this judge was once in that position. And she's thinking about how she was once in that position and now she's in the position of watching her, and she's kind of comparing her to herself when she was younger and stuff like that. And it's just a sort of an admiration, and she's paying attention to the details to make sure, like, make sure that she doesn't say anything wrong or say anything off, and she's just very attentive, very interested in what she has to say.
You saw the nature of the stop. There was no animosity between the officer and the driver. It was rather peaceful. They were engaged, banter back and forth. He would have, as he testified, he was trying to determine whether he was going to cite her or let her go with a warning. And then you have an individual, the defendant, introduce himself to a situation. Traffic stops, Your Honor, are inherently dangerous, particularly in crowded parking lots, I guess anywhere, I would venture to say. This officer was reasonable in thinking that anyone who would approach in the manner that the defendant approached his scene would have a reason to fear for his safety, or at least be suspicious of this individual's motives coming in. The officer had no problem with the recording. The officer had no problem with the defendant observing. It was when he inserted himself into this lawful detention that was occurring with the Hyundai driver that the officer turned his attention onto the defendant. This is not a First Amendment issue. This is an individual who took what he perceived to be his rights too far. The officer was well within his right, as well as acting reasonably when he asked him to back up. That 21-foot rule, it's appropriate. He said that was the training that they received in terms of the distance that's allowed for someone who needs to do them harm. It's a threat assessment. We don't know when the defendant approached whether he had a gun concealed, whether he had a knife concealed, whether he had other weapons. And you'll hear multiple times in the video, Officer Bork yelling, "Stop reaching, stop reaching." This is an unknown, when defense counsel asked Officer Bork all of these questions about how it is that you do this, and Officer Bork kept responding, it depends on the situation, it depends on the totality of the circumstances. Here was an officer acting alone, individually, engaged one-to-one with a driver. He had no problem with it. You insert another individual who enters the scene in the manner that the defendant did, and now this officer's attention is going to be divided. He had every reason to fear for his safety as well as that of the driver. Again, if he had just complied with the officer's commands or demands to back up, and a lot was made about, hey, he didn't have an opportunity to tell the defendant exactly how far back. As the officer testified, even just with the, hey, back up, the defendant didn't back up, not willingly. That's why the officer had to continue to engage with him and force him into the situation. Had he complied, he would not have been charged with obstruction. Had he complied initially, he would not have been charged with the resisting. The officer was, you are going to have to assess credibility. There's nothing in the video.
Seeing the plaintiff attorney is really painting a picture, and she's painting a picture that is false. And the falsities could be pointed out, but it hasn't been done so in a way that the judge would hear, and so it's just like this false picture is being painted to the judge, and the judge is just rapt with attention, just constant eye contact, she's rapt. So she believes this woman, no matter what she says at this point.
Or Officer Bork's testimony that would cause the court to question his veracity or his intention for that matter. He was very honest in that he didn't believe the defendant wasn't trying to harm him necessarily with the SWAT. That's why the defendant wasn't charged with the battery on a protected person or a police officer. But that SWAT...
Judge, we could have charged him with something greater. We cut him a break by charging him with this smaller thing. So of course he's guilty of this smaller thing, because he would have been guilty of this bigger thing if we had decided, but we decided that, nah, he's not guilty of that, but he's guilty of this. And it makes their story sound so strong, doesn't it?
I would argue, was meant to resist. At that point in time, the officer was trying to detain him and subsequently arrest him on the obstruction, as depicted in the video. And so, at this point, I think we proved by beyond a reasonable doubt that the defendant did hinder Officer Bork's investigation and detention of the Hyundai driver, and that he resisted the officer's arrest and or attempt to arrest him. And so we would ask that you find the defendant guilty of both.
All right, thank you. Ben?
Yes, Your Honor. So first of all, you cannot obstruct an unlawful order. I disagree with the state that this is not a First Amendment issue. The First Amendment in this context actually has two parts. There's the filming and the right to film within a reasonable distance. The case law in all the federal circuits, Your Honor, there's no 21 feet rule that's been approved by any court of which I'm aware. That there is a 10-foot rule. That seems to be the rule that is applied by most of the federal circuits in interpreting the First Amendment. I submitted a bench brief that kind of goes through that issue, if the court's had a chance to review that.
I don't have that. When did you submit it?
It was submitted yesterday, Your Honor.
I mean, at this
Wow. Just wow. Like, there's this whole argument, a very effective argument that could be made by the defense, and he finally submitted a First Amendment brief yesterday. Now, from what I've shown you so far, you don't realize that this case has been continued like 3 or 4 times and extended out several months. So this defense attorney had plenty of time to submit this brief, but he submitted it yesterday. Ineffective counsel.
At this point, I would move to strike because it's untimely, but I got it this morning when I walked into court.
I like Michael Mee a lot. He's a really nice guy, really sweet person. That doesn't change the fact.
I don't care if your attorney is a nice guy and a sweet person. Like, people fall into these traps all the time. Oh, this guy says the right thing. He's polite. He's very nice. He says he wants to help me. And it's like, it doesn't matter. None of that matters. I want a ruthless bulldog to be my defense attorney if I ever have one. If I ever have a defense attorney, I want them to be a ruthless bulldog. I want them to zealously defend me to the best of their ability. I don't want them to be nice to me while they fuck me over in the courtroom. I want them to, I don't care if they're nice to me at all. I want them to be straightforward, honest, and I want them to zealously defend me as though it was their body that was on the line, as though they were the ones who might go to jail. And, like, why do you fall into these traps of this person is a sweet person, he's a nice guy? Why? Because he compliments you? Because he fed your dog one day? Like, because he, brought you French fries when he met with you? Like, none of that matters one bit. Not one bit. And these attorneys are getting paid an awful lot of money to do very poor jobs.
He didn't get the First Amendment brief submitted, that he didn't file a motion to dismiss the case before the case began. He didn't present case law that shows that I have a right to film cops before the trial ever happened in pretrial hearings. He didn't do the things he was supposed to do. And so
This defendant could have filed a motion at the beginning challenging the applicability of the code. He could have simply challenged that, hey, the statute that you're accusing me of violating, do you have any factual evidence that it even applies to me? And if he could have stood on that, and he would have won. The case would have been dismissed. He wouldn't be in jail right now.
So there's a problem. In the appeal brief, you can read it, the appeal brief that will be heard on July 10th. The lawyer that I have now, my appellate attorney, he brings up ineffective counsel because it was ineffective. It just simply was. And I don't want to beat anybody up, but there were some bad mistakes made here. And then when that judge searched me, Michael Mee didn't object to me being searched. And then when she sentenced me to 6 months in jail, he didn't object and say, my client's not remorseful because he didn't do anything wrong, and he shouldn't be put in jail for 6 months. I just don't think that Michael Mee is a trial attorney. And number two, I don't think it should have gone to trial. I think Michael Mee should have submitted that First Amendment brief way before 2 days before the trial, and he should have submitted a motion to dismiss the case before it began.
Go ahead.
So the officer's testimony that there's essentially this 21-foot distance where anybody can charge an officer and cause physical harm to it.
Check out this defense attorney's body language. He's standing up, he's got his arms crossed. He's not looking the judge in the eye. He's making his arguments to this wall over here. And it shows his discomfort, his ineptitude. He's not used to being in this position. And it's very revealing just by looking at his body language.
If that is applied universally, Your Honor, it totally diminishes and violates the First Amendment. That is, as the officer testified, a 21-foot radius that he can attempt to impose. I believe his testimony was anytime there's not an obstacle between a person and somebody that law enforcement is interacting with. And that's just not what the law requires, Your Honor. The First Amendment gives, whether they're media, new media, old media, it gives individuals the right to film government agents. There's no dispute that that's the requirement. And if the officer is applying this 21-foot circumference to all law enforcement interactions, he's effectively eliminated the ability to film law enforcement going about their duties. The commands to not talk to the driver are also not based on any actual legal justification. There's no right to privacy in public, whether you're engaged with law enforcement or not. There's no requirement or no statute, no law that citizens can't interact with drivers that are interacting with law enforcement. So what's taken place here, Your Honor, is that this officer has taken it upon himself to essentially act as the legislature and created.
Oh, there she lost interest. The judge has lost interest now, and she's starting to read through paperwork and get ready to make her sentencing. She doesn't give a shit about what this guy is saying now. It doesn't matter what he's saying. It's irrelevant. She's not listening. She doesn't care because she has already made it up in her mind how she is going to rule.
These rules that have no basis in any law and in fact are contrary to the First Amendment. Again, you can't obstruct an unlawful demand, so there is no obstruction of justice here. Resisting arrest, Your Honor, the court can see the video. Essentially what happened is he walked over to the front of the vehicle. There was some dispute about why he was being detained. That was discussed. The case law in that area, Your Honor, is that if it's an unlawful arrest, which it was in this case because they're essentially arresting him for violating these unlawful.
What case law? He's referencing case law, but he hasn't laid the foundation. He hasn't stated the case law. He hasn't given any information about the case law that he's talking about. So the judge doesn't give a shit about what he's saying. She doesn't care what he's saying at this point because she hasn't read the case law because he hasn't submitted the case law. But he's referencing it, and it's a big mistake to reference something when you haven't laid the foundation.
Orders that they're pronouncing. Again, the case law is you can passively resist an unlawful arrest, and that's all that occurred here. Thank you.
Yeah. All right, Mr. DeCastro, please stand. The problem with the argument that your attorney makes is it completely fails to consider the safety of the officer and the safety of the driver. The officer doesn't know who you are.
And she's correct. She's giving her reasoning, and she's pointing to the weakness in the defense's argument. And she's correct because this defense attorney did not have the ability to see what issues were being brought up and then how to fight against them. He wasn't doing any of that. So this judge now can point out all of the mistakes, because now it's too late to correct any of those mistakes. So now she can point out what the defense attorney failed to do and why she is making her ruling this way.
And the driver doesn't know who you are. And you don't have any right to interfere with that officer doing his investigation and deciding if he wants to issue a ticket to this driver. And you also don't have any business approaching the driver. The driver didn't ask you for help. The driver didn't say, help, help, you know. You didn't see an altercation happening between the officer and this driver. The officer didn't protest that you were filming. There's no problem with filming. You can film, it's fine, all right? But you did interfere with his investigation. You did interfere with his ability to do his job. You did put him in a position where he is concerned for his safety and the safety of the driver. So I believe the state's met their burden beyond reasonable doubt. I'm going to find you guilty of obstructing a public officer and resisting a public officer.
This is the judge's picture right here, and this is what she really looks like. See the difference?
So I'd like to hear from the state and then your attorney prior to sentencing.
And the judge says, well, the driver didn't ask you for help. Well, neither did George Floyd. George Floyd didn't ask any of those people for help to be filming. But if I'd been filming the cop beating on somebody, then I'd be a hero. But because no one was beating on anybody, then I should be arrested. Which is it? Which kind of country do we live in here? It's absolutely preposterous. And then, so the judge buys that there's some magic 21-foot rule, says that the driver didn't ask for my help, and then she creates this facade that there's a 21-foot rule, but there's not.
It's not that she's creating a facade that there's a 21-foot rule. It's that she sees where the cop was coming from. And for that cop to have done anything wrong, that also sort of has to be willful too, in a way. Like, you know, this case here is about showing beyond a reasonable doubt that DeCastro willingly violated these statutes, and that could have easily been won. He could have easily beat that. He could have easily shown how he wasn't willfully resisting at all. So, but what she can see is that the cop was trained that there was a 21-foot rule, and all he was doing was following his training. And, it, you know, to her, maybe it does seem reasonable. Yeah, 21 feet away, I can stop somebody who might be rushing me with a knife. But it's not that she's saying, yeah, there's this 21-foot rule to recording. It's that she's looking at the police officer that was a witness. She's looking at his testimony, and she's seeing that he believed that that 21 feet is what makes him comfortable. He believed that. And, you know, there's no mens rea, there's no guilty mind in the witness that what he was doing was wrong. So, you just have to understand how the system works. And if you're getting into this, why wouldn't you educate yourself on how the system works? You know, if you want to be an auditor, then why not just look at how the system works so that you know how to navigate it?
Your Honor, in terms of sentencing, I would ask that our defendant enter and complete an impulse control class. I would ask that the court lobby a $500 fine or the equivalent in community service. I would ask that the defendant be ordered to stay out of trouble for the pendency of the case. And I would ask for a 90-day suspended sentence. And that's on as to each count to one concurrent. That's our request. Thank you.
Your Honor, I'm asking the court to sentence the defendant to credit for time served for these offenses. Even if the court concludes, and the court did conclude that he didn't have the right to do what he did, I think the court can see that he sincerely believed that he had the right to do so. That's based on his past experiences and the training he's received in reference to the First Amendment. I don't think there was any intent from the defendant to engage in any wrongdoing in this case, Your Honor. And that being the case, especially because of the public policy interests at issue.
So when you say he doesn't wish to engage in any wrongdoing, it seems to me from observing him in the video that he wants this. He wants to get arrested. He wants to get into an altercation with police officers. He welcomes this. This helps his YouTube channel. He called the officers here in my courtroom today pigs. He called and he's nodding his head up and down.
So if you call a police officer a pig, and then they tell you that you're being insulting, why not just say, why would it be an insult to call someone a person in government? You know, you can totally negate this whole notion that to call them a pig is this thing where you're looking down on them and disrespecting them. And you can say it's just an acronym for person in government. Pig. Person in government. Pig. I can't help how you take it, Judge, or how the police officer takes it. I'm just using an acronym to show that they are a person in government.
Apparently he hates every law enforcement officer in the United States. All right, please stand up, sir. Are you finished with your request for credit for time served?
I would just emphasize, Your Honor, that the defendant testified and he sincerely believes that he is providing a public service when he reviews and films these incidents. I understand the court may have a different view of that, but when we're talking about First Amendment public policy issues such as supervising people involved in government, I think that is something the court can take into consideration, not to have a chilling effect on that. I'll submit on that, Your Honor.
All right, Mr. DeCastro, please stand. I hereby sentence you to 90 days in the Clark County Detention Center on count 1, 90 days in the Clark County Detention Center on count 2, to run consecutive for a total of 180 days in custody. Thank you.
Sentence suspended or?
Oh, no.
Oh no, the sentence isn't suspended. Even though this guy has been in jail for months already, they're not going to give him credit for that time served. She's throwing the book at him. She's basically giving him what amounts to the maximum penalty because she has a bias against him, because he doesn't like persons in government. And it's like, that could be pointed out, but at no point is it pointed out.
We're going to start right now.
So yeah, that's probably about as far as I'm going to go. There's a little more after the video where DeCastro explains the situation and stuff, and he's right about a lot of things, but he had a very lousy attorney. He himself didn't understand the process, and so he relied on an attorney. He attorned his interests to that attorney. So now the attorney is acting as though the attorney is him, but the thing is, the attorney's body isn't the one that gets thrown in jail, it's DeCastro. So when you put your destiny in someone else's hands, and that person at the end of the day has already collected their money, and it doesn't really matter if you went to jail or not to them. They can say it matters, they can be a nice person and show sympathy, but that doesn't mean that he's the one going to jail. So he's not defending you like he would defend himself, is he? So stop putting your faith in these attorneys, because they're not going to help you. Freedom is in your own mind, and you can help yourself a lot if you just learn how to stand on the actual truth and learn how to see what is actually going on around you. Because that insight, if he had had that insight into what was actually going on around him in this courtroom, then he could have won. He could have won. But he didn't, and he had ineffective counsel. So here we are. Thank you guys. Have a good night.